Hi, guys. Hi, guys. Alena Shautsova, immigration attorney from New York is here. And today we're going to talk about this topic, how green card holders get into trouble. You may think, why would I want to know that? I'm not a green card holder. Guess what? Most of green card holders' problems usually arise or start before they get a green card. So it's good to know how to avoid these mistakes, how to make sure that you are not going to be one of those unlucky people who end up in removal proceedings after they receive a green card. So please share this stream so more people will be able to join us and more people will be able to find out how to protect themselves from big mistakes. Hi guys, don't forget to let me know where you're watching from. And today again, we're going to be discussing how you can protect yourself from ending up in removal proceedings after you get a green card. And if you are a green card holder, you will also know what happens. How is it that people who are on their way of receiving citizenship end up in removal proceedings instead? And then they're looking for ways to save their green cards. So thank you very much for joining. And don't forget, also type up your questions. In the end of my presentation, I will be answering your guys' questions. So let's start. Well, you know, green card is a very good thing when you receive it, right? It allows you to reside in the United States, sponsor some of your relatives, not all of your relatives, but it's also not citizenship. It's not citizenship. And many people don't reach citizenship level, right? What happens? What disqualifies them? And how is that they get into trouble? So from my 15 years of experience, I'm going to tell you that the first way, I guess, if we have this popularity contest, the first way a green card holder would end up in immigration proceedings would be if and after they travel overseas. What happens? Why is that when they travel overseas, they get into removal proceedings? Well, it happens because if you ever cross the border after travel overseas on your way to your home in the United States, you would see that CBP agents have these magic computers there. And those computers, I would say they're like crystal balls. They know everything about you. If there is any issue in your immigration file, if you had any arrests, those computers are going to have that information. Hence, when a green card holder comes from overseas travel back to the United States, a CBP agent clicks on that button and they see whether there is some alert in your file. Usually it would be a criminal arrest or conviction, or it would be something related to fraud. And once they see it, they may call you for a secondary inspection. They may decide that they will be placing you in removal proceedings right then and there. But regardless whether it happens right then and there on the same day, or it happens a little bit later, a notice to appear will be issued and a green card holder will be placed in removal proceedings because they came into the spotlight, they had this attention directed at them at the border, and now the government knows where they're at, what they're doing, and that they have an issue and they're removable. How to avoid this issue? Not to travel? Well, not quite. What needs to happen is that you need to consult with an immigration lawyer and potentially criminal lawyer before you travel. If you have any issues in your immigration file, for example, fraud, maybe you got your green card as a result of providing incorrect information about you. Maybe you had some criminal arrests or convictions for shoplifting, firearm possession, something related to controlled substances, consult with an attorney. Maybe you can file a motion to reopen for those criminal charges that now is a problem or maybe a problem for you for your immigration case. Maybe you can resolve your fraud situation somehow prior to being placed in removal proceedings. Also, I'm going to tell you that usually if you received a green card as a result of fraud, you're either going to be deportable, right? You will be removed from the United States, or you will qualify for something else, for example, waiver in removal proceedings. So the key here would be to avoid this issue and file for the waiver of misrepresentation or fraud at the time when you are filing for your green card. This will be the best possible way to resolve the situation and open your way for citizenship and safe application. So that's one way when people get into trouble, right? They travel overseas and then they get into trouble because those computers reveal some information about them. Second way would be when a person submits their application for a green card, for a citizenship, believe it or not. Why? Because at the time of your citizenship application, the government is going to study your file again and scan it for any mistakes. You will not believe it how many times I received phone calls from people who got into trouble after they submitted their applications for citizenship. Sometimes USCIS determines that a person's green card was approved in error. For example, they entered on K-1 visa and another spouse sponsored them later for a green card, and somehow that green card was approved, even though it should not have been approved, because a K-1 entrant can adjust their status only if the same spouse is sponsoring them, unless they qualify for VAW benefits from the same petitioning spouse. Or, for example, a person was sponsored for a green card by their parent, and they claimed to be unmarried, but they've been married before they entered the United States using that immigrant visa issued to them as unmarried son or daughter. And this, of course, will be discovered later when the person is filing for citizenship now, and they show that they have a spouse, for example, they have children, they put the date of their marriage on the application. So another example would be, one more example, which is very real, is when a person is submitting their N400 application and asking for a name change. Why would it be a problem? Well, in most of the situations, it will not be. But if the name change is unusual, USCIS is going to do the deeper background checks. And believe it or not, in some cases, USCIS discovered that a person claimed to be someone else when they received their green card. And when they're filing for citizenship, they're trying to claim their original name. And that's, of course, is going to present a problem for them later, and they will end up in removal proceedings. So N400 is another step when USCIS is going to check validity of your status, okay? And if they find that there is any inconsistency, any fraud, anything else that presents a problem for you, the person will end up in removal proceedings. And finally, third way, and you probably were aware of it already, when a person who has a green card may end up in removal proceedings would be criminal arrests and criminal convictions, guys. Something silly, such as shoplifting, for example, may cause a big problem for a person, and they may lose their status. Most of the times, of course, it's going to be something more serious. Usually, I've seen problems related to controlled substances, especially something that would be considered to be an aggravated felony, and the person would be losing their green card. So how to avoid this? Well, hire the best immigration law and hire the best criminal defense attorney you can find. An attorney who's going to give you correct advice will consult with a good immigration lawyer, and you will not end up as someone I have consulted recently who was advised by their criminal attorney that the plea that they were taking is not going to be a problem for the immigration. And of course, it became a problem. And now this person is seeking, looking for ways to take the plea back, right? Because they basically relied on incorrect advice and ended up in a bad situation. So these are common ways as to how one would experience issues, guys. Experience issues if they're already a green card holder. And now, if you have some questions, I'll be very happy to answer them. Hi, Rashid. Hi, Sang. Hi, Nias. Hi, Rafat. Let's see. I'm asking about UIR 29. How long does it take after denial of I-130 previous fraudulent marriage? Are you talking about the appeal that you filed because I-130 was denied due to previous fraudulent marriage? In my experience, appeal with the Board of Immigration Appeals for I-130 denial is going to take about 2 years. All right, about 2 years. I know, very, very long time. Hi, YY. How long we have to wait for the process? Please let me know what process you're interested in. USCIS processing times, guys, are published on USCIS website. I have to tell you that due to COVID and other issues, almost for all applications, processing times increased. And many people are waiting, for example, for the asylum cases to be called for the interview. And even though people should be called for the interview within very short time, if we're talking about the new filers, I see that it's not the case very often, unfortunately. Even though USCIS says that if you filed recently after 2018, you're supposed to be called for the interview within the first 60 days of your filing. Some people are still waiting for a number of years before they're filed. And unless you have a very good reason to file a request to expedite your case, you'll be stuck in this backlog. Hi, Karma. I believe I just answered your question as well. The processing times published on the USCIS website. A family-based petition in the United States, we're talking about marriage-based petition filed by a U.S. citizen for their spouse, is usually going to take about 11 to 13 months to be resolved. Hi, Shabir. I have applied. You have received the determination that you qualify for the U visa, for the U visa related work permit, right? And it is more than 1 year. How long it will take? My case filed in February 2019. Are you stating that you filed for the U visa? Because I think that's exactly what's happening. I don't think you have received the determination yet regarding your employment eligibility. You know why I don't think so? Because 2017 cases have been reviewed only a couple of months ago. That's what USCIS actually confirmed. So I don't think that you received that determination that would qualify you for the work permit based on the U visa pending yet. And how long it's going to take, I truly do not know. If a couple of months ago they were in 2017, I would say another 6 months minimum, if I had to guess. Hi, Sidra. Hi, Eli. Mom and I came to the United States in 2013, both on tourist visas. Since then, I got married, obtained my green card, and I will be a citizen soon. If my mom here is out of status, can I petition for her green card? And the answer is yes. Yes, you should be able to. So your mom, once you become a US citizen, will be considered an immediate relative, right? And the law provides this one exception only for immediate relatives when they forgive you for overstay of the visa and for unauthorized employment, if you are an immediate relative. So, for example, a spouse of a US citizen, a parent of a US citizen who is over 21 or 21 or older, a child of a US citizen would qualify for this specific exception. You will be able to petition for your mom, and if she doesn't have, let's say, any criminal arrests, never claimed to be a US citizen, never left the United States and unlawfully came back, she should be able to get her green card in the United States. But of course, consult with an attorney who, once again, is going to review your mom's eligibility for the green card, right? To avoid any issues. Hi, Soul. Hello. Does USCIS office ask about how and why I became out of status during interview? And do USCIS know everything about service help desk? USCIS knows a lot. Do they know about service help desk if you submitted any inquiries? I mean, I'm sure they can get that information, right? I cannot tell you for sure what they know or what they don't know. I don't think any immigration lawyer can, unless they worked for USCIS. But I suspect that any correspondence that you shared with the government would be available to the government if they decide to do the deep background checks. Now, the main thing that you need to remember when you're filing for adjustment of status is that you should be truthful, all right? If you have any concern, you should consult with an attorney and work with an attorney. Does it matter how and when? I mean, when they will know, of course, when you lost your status. But what was the reason? It depends. If, for example, you claimed that you suffered some hardship and you filed for, based on that, you filed for work permit related to hardship and that was not true, it may be a problem because you lied on your application, right? Or somebody lied on the application. But generally speaking, if a person, loses their status, government knows about that, or they will find out when the person files for adjustment of status, change of status, an exact reason, unless it's related to some ground of inadmissibility, usually does not matter, right? What was in person's head, whether they thought that they're going to have a better life in the United States or they had some other circumstances, unless in certain specific cases you argue hardship, and the reasons do matter. For example, you're filing to be reinstated as in student status, then the exact reasons may matter, okay? I would say if you're that worried about that, talk to your lawyer and they may be able to give you a better advice and maybe give you some, more comforting information, because I think you are stressed out about that point. Usually it's not a big deal, okay, why a person exactly overstayed. All right. Hi, True Wisdom. Hi, Alena. Can you tell me what do you think the process time is out of the country for 20-year-old US citizen to file for a parent? All right. So 20-year-old, 21 years old US citizen is filing for their parents who are out of the country. Well, the petition, I-130 petition, will probably be approved extremely fast. I had a case where such a petition for a parent by a child was approved within 3 months. But then a person will have to deal with National Visa Center and consulate. And here where we see great delays. I would not be surprised if the person will have to wait for the interview for a year. And of course, it depends on the exact location of the person, okay? And if there is a need for a waiver, it's even going to take longer, all right? If parent needs a waiver. Hi, Mars Layosa, watching from Connecticut. Yay. Hi, Nina. How long does it take for a waiver? Well, I guess it depends on a waiver, right? And how the need for the waiver came about. If you're filing for I-601A waiver, these days you're looking at about 2 years of wait time. If you're filing for inadmissibility waiver and the need for the waiver came about after your interview for adjustment of status. Such waivers usually approved very, very fast. Just recently, I had a case where the waiver was approved within 30 days. Okay? And also, if you're filing for the waiver and request your case to be expedited, the case also can be approved extremely fast, within, let's say, 3 weeks. So it depends. But usually, I would say these days, you're looking at 9 to 15 months, right? Usually. But again, it depends. There are so many variables here. I will not be able to comment on all of them. All right. Hi, Dada. How long does USCIS make decision on remanded appeals sent from Board of Immigration Appeals on I-130? On I-130, there was an appeal, they remanded the case. I truly do not know. I will not know that. I'll be honest. Remanded appeal from the Board of Immigration Appeals. Were you in removal proceedings, or did the Board of Immigration Appeals decide that your I-130 should have been approved and USCIS made a mistake? I really would not know. I'll be honest with you. All I know that if we're talking about appeal of the denied I-130, it takes about 2 years to receive decision from the Board of Immigration Appeals. Okay. All right, guys. I see some questions about the work visas. So I actually receive a lot of inquiries about the work visas in the United States. I'm going to make a special video about this because the topic is just way too big for me to be able to talk about it within this couple of minutes that we have left. Work visas can be usually EB2, EB3. For EB2, EB3, you usually need something called labor certification. However, it's possible to submit EB2 application without the labor certification and without employer if you're filing for national interest waiver and you're going to get approved. Also, certain people of extraordinary ability may qualify for self-sponsorship under EB1 category, and they don't need labor certification or an employer. I'm going to have a separate video about this because it's a very interesting and big topic. I will have to tell you that these days EB3 sponsorship is extremely popular, and it is possible to be approved when an employer is sponsoring you. But guys, you will need to have an employer. It's not possible usually unless you have exceptional ability or extraordinary ability, or you're filing for national interest waiver, meaning that you have some very high qualification and you can show you're going to be useful for the United States and national interests of the United States. Unless you can show that, you will have to have an employer in the United States. And even if you're filing for EB1 extraordinary ability or national interest waiver, it would be good if a potential employer submits a letter supporting you, stating that they would be interested in working with you, right? That's in a nutshell about the work visas. And you can learn more about the work visas on my website, shautsova.com. Well, guys, thank you very much for watching and joining. Thank you for sharing, liking this video. If you have not signed up for my YouTube channel, please do so. And please follow me on Facebook. So I will see you soon with more interesting information with regard to United States immigration laws. Thank you, guys.